Joining us now to discuss, friend of the show, James Sample, professor of law at Hofstra University and former attorney at the Brennan Center for Justice's Democracy Program. James, it is great to see you again. What would it mean for federal judges to leave Halligan's former position open right now?
Well, the federal judges there's a statutory scheme. U.S. attorneys are officers under the Appointments Clause of the Constitution, which means that they are presidential appointment with Senate confirmation. Interim U.S. attorneys are inferior officers, and inferior officers can be appointed by the president alone or by Congress or by the heads of departments, in this case, the Attorney General. But you only get one of those. You get 120 days, and the statutory scheme, Congress gets to make the decision as to which of those three scenarios you get. And Congress made that decision. Statute called 28 U.S.C. Section 546, and it sets out a 120-day limit. And the reason it sets out a 120-day limit is that Congress wants to maintain its role in this process. That is the check on presidential power. That is the check in the nominations process. If you can take 120 days and stack 120 on top of 120 on top of 120, you can completely circumvent, as a president, the congressional role here. So district courts, in this instance, are the route that Congress has chosen in that statutory scheme for the inferior officer who is an interim U.S. attorney. And when 120 days are up under the first step, it goes to the district court. So what would it mean? It wouldn't mean anything dramatic. It would just mean that it would be unlikely that they would choose Lindsey Halligan, and they would choose, presumably, somebody who's relatively sort of, quote-unquote, politically neutral. You wouldn't want to choose.
Or has any experience.
Or has any experience.
More qualifications for the job, perhaps.
She would not be the first choice of most district court judges.
So, James, the AG Pam Bondi has said that she plans to appeal this decision. What does that mean going forward for reviving the cases that were effectively tossed because of this decision?
Bondi really has a decision to make. I know she has talked tough about appealing immediately, but the decision here, there's a fork in the road. If she appeals, that's doubling down on really wanting to get at James Comey and Letitia James. Because appealing, number one, I think, and this is just opinion, but I think you lose. This is a relatively clear-cut issue, at least with respect to Lindsey Halligan's appointment. There have been three other scenarios around the country with other Trump interim appointees. In New Jersey with Alina Habba, in Nevada, and in California, three other individuals who were in the exact same situation. They got less attention because they weren't prosecuting Jim Comey and Letitia James, and they weren't put in those offices for that exact purpose. But in those instances, the line U.S. attorney prosecutors, assistant U.S. attorneys, supported the prosecutions that those interim appointees went after. So those indictments were not voided. Here, if Pam Bondi does appeal and lose, that's essentially doubling down on the idea that you really, really want to get at Jim Comey, you really, really want to get at Letitia James, and you're not worried about the political loss. The more productive in other respects route would be to accept the district court's nominee or to go this is crazy in America today, to go through the actual statutory process and constitutional process of presidential nomination and Senate confirmation. You literally, as president, or the president, you are a Republican, you've got Republicans in the Senate. The idea that you can't get someone for one of the most important districts in the United States for a prosecutor, I mean, the Central Intelligence Agency is located in the Eastern District of Virginia. This is an important office.
But then I thought there was also an issue with the Comey prosecution that the statute of limitations will have run out.
Absolutely.
So if they go the more normal route that you were describing, does that foreclose the ability for this president to prosecute, wreak retribution upon, whatever verb you want to use, to revive this case against Comey?
It's uncharted territory, and there are two arguments. The government will argue, and has already asserted to some extent, that there is a statute, a different statute, 18 U.S.C. Section 3288, which gives the prosecutors 6 months, gives federal prosecutors, when someone was indicted, 6 months from the date of a dismissed indictment. That being said, Comey will counter, and Judge Curry, in a footnote 21 of her opinion, actually put in some language that it's a little bit off topic, it's a little bit beyond the scope for her, but she was foreshadowing the argument that she anticipated would come on appeal. And she said that that statute is really only applicable when the initial indictment was valid at the time. Here, the prosecutor was acting essentially ultra vires, out of beyond the scope of authority because there was no authority and no one else supported it. So in that scenario, Comey will argue the statute of limitations has run and the initial indictment did not toll the statute of limitations. That is going to be a kind of meta argument if they choose to continue to pursue Jim Comey.
With so many different cases in the air and different laws to break, there's just so much happening right now.
Opportunities.
Exactly. But big picture, where are you on kind of where we are with the state of the rule of law and how our institutions are holding up? Because the Washington Post interviewed about a dozen judges, former judges and soon to be retired judges, and they said that they are really concerned that the rule of law is unraveling.
It's a pick your metaphor scenario, Elise. You know, the boiled frog. It's a little bit like climate change to some extent, right? People don't notice that half a degree every decade, but over time these things add up. And we're not going to wake up tomorrow and find that the rule of law is gone. But there are some real changes, and those real marginal changes are adding up. And the incremental differences do, in the aggregate, really make a difference. Judges are speaking in ways they have not been speaking. Retired judges are speaking in ways that we've really never heard them speak. They're afraid in terms of rule of law. They're afraid in terms of their safety and their family's safety. Those are real concerns. And the rhetoric coming from the administration with respect to judges. I mean, Kristi Noem over the weekend, Todd Blanche saying that the Department of activist judges, Todd Blanche saying we are at war with the federal judiciary. The Department of Justice is not at war with the federal judiciary. The federal judiciary is a neutral actor trying to uphold the checks and balances that make the Constitution, make the system function.
Well, we hope that the system continues functioning. James Sample, thanks so much for joining us this evening.